Ladies and gentlemen, we want to welcome you to Liberian Senate, where the witnesses from the Inter-Ministerial Concession Committee are here present for the public hearing regarding the third ArcelorMittal amendment is being held. So the oath is being administered and the witnesses
No, I want you to take Quran. Thank you. No Quran, I never killed before.
So, introduction of the IMCC members. Introduce yourself.
Honorable Chairman, distinguished members of this joint committee, my name is C. Deliswa II. I'm the director of the sessions, the public-private partnership, and the National Investment Commission, representing Judge Weah.
Honorable Chairman and distinguished honorable members of this committee, my name is Anti-Money Laundering. I'm the Minister of Mines and Energy.
My name is Weah. I'm the Deputy Minister for Operations of the Ministry of Mines and Energy.
Honorable Chairman and honorable members of this committee, my name is Weah, Deputy Minister of Administration and Public Safety at the Ministry of Justice and currently the Acting Minister of Justice.
Honorable Chair, distinguished member of the committee, my name is Otello P. Manso,
Deputy Minister for Administration, Ministry of Labor, representing Council of Water.
You agree? So we ask
Introduce themselves. We start.
Order, Mr. Chairman. Mr. Chairman, order, please. Please, order. I would like to know, before senators can introduce themselves, we invited, according to this agenda, members of the IMC. How many of them that were invited? How many were invited? How many absent? Let the record state.
We rule on that already.
No. We rule because we had deputies, other people, not the actual heads not here. But I want to know what constitutes the IMTC for this hearing. I want to know.
We
How about this one committee room? We want to know.
We rule on that. The center ministry is here, and then we rule on that. How many years we can come?
I just want to know.
Senator, please introduce yourself. Please introduce yourself.
Hello. People that were invited.
Hello. All of them are here.
We start them as a famous.
Yeah, please introduce yourself.
My name is Weah.
I
come from my county.
for your information, I said, you here.
I'm a member.
I can't be senator, then deputy assistant. Coming here, I'm going to be here. I said, must you to be here?
Yes.
Senator Brad, I think.
I'm going to do an introduction.
Okay. Senator Brad,
Oh, I thought you were back there. You're doing that very well. Why the Papa can't come?
Colleagues, on the ground. Let us discuss the committee room now. We all back out there. I'm General Alexander Tyler. I represent Bowman County, and for the purpose of this hearing, I'm a member of the committee on judiciary and finance.
Darius Miller. I represent Monterey County, member of the Judiciary Committee for the purpose of this hearing.
The chairman.
Oh, that's myself. Oh. That's the chair of the Judicial Committee.
I'm Sir Joseph, for the purpose of this hearing, I'm member of the committee on the NRC and the committee on business.
My name is Wellington G. Smith. I represent Riverside County, chair of the Agriculture Committee, and for this, the purpose of this gathering, I'm a member of the Management Committee. Also,
Ways, Means, and Finance.
Chair Glover Brown, Senator Maryland County, Ways, Means, and Finance.
Senator Rankin, County, Chair of Health.
I'm a chair, co-chair committee on Finance and I'm on Concept and Investment.
Who got a live board?
Chairman of
Who chair got a live board? Yeah.
I'm Senator Bonzo County, representing the people of Backward County, co-chair on concession, member on mines, member
Samuel Koga.
My name is Liberian Senate. I represent Great Creek County. I chair the Committee on Concession and Investment and co-chair of the Joint Committee for this year.
And I'm Senator Smia Boyman-Taylor, chairing the Senate Committee on Lands, Mines, and Natural Resources, and chair for the Joint Committee.
And so the introduction
At this junction, we ask
has been concluded with the chairman of the committee.
Distinguished colleagues, senators, our invited guests, members of the ICC, we want to, on behalf of the Joint Committee, officially welcome you here at this meeting. Senator, thank you for joining this hearing. We want it to be very constructive. Senators, because of the importance of this discussion, will be given enough time to allow the ICC members to convince them on the reason for which they want this agreement to be endorsed by the Liberian Senate. You, our guests, you are also welcome. You will be individually, by institution, making your presentation. The reason for which you want the Liberian Senate to ratify this agreement. By procedure, our press, the people in the gallery here, we don't cheer, we don't boo. If anybody behind there who is interested in asking any question, please pass it to a senator. The senator can ask your question. But here, only senators are allowed to ask questions. Our guests, please, whenever a senator asks you a question, please allow the senator to pause before you begin to answer. And please answer to the point so that the discussion will not be too long. Again, you are all officially welcome. Thank you very much.
Thank you, Senator Batikoa, for the ground rules laid. At this point,
Oh, okay. Thank you, Mr. Chairman. My name is Yan D. Twine Jr., Senator of Nimba County, lead campaigner for concessional compliance in the Liberian Senate. Thank you.
Thank you, Senator Twine. So we asked the IMCC member to tell us the important and the necessity of this amendment. So we asked the Minister of Mines to lead the discussion.
And so the Ministry of Mines is being called upon to start the engagement.
Statement from the Ministry of Mines and Energy on the amendment number 3 to the agreement among the government of the Republic of Liberia and ArcelorMittal Liberia Holdings Limited and ArcelorMittal USA Liberia Holding FCC at the Honorable Senate public hearing today on January 21st, 2026. Honorable Chairman and members of the Senate's Joint Committee comprising the committees on lands and mines, construction and investment, judiciary, human rights, claims and petition, and ways, means, finance, and budget. This chair amendment to the Mineral Development Agreement between the government of Liberia and ArcelorMittal Liberia Limited is an instrument realized after years of tedious negotiations. These negotiations were guided by the national aspiration entrusted to the government negotiating team to ensure that Liberia receives its fair share of benefit from its natural resources. As a result, determined efforts were made by the government negotiators to enhance Liberia's benefit, not only from the mineral resources themselves, but also from the Nimba to Grand Bassor rail infrastructure. Significant strides were made to improve provisions in the existing NDA to strengthen the government of Liberia's oversight and compliance mechanism and to ensure that mining, rail, and port operations are properly aligned to deliver greater benefits to the Liberian people. Importantly, this amendment introduces a late penalty provision, which provides an additional compliance enforcement tool and ensure that termination of the MPA is no longer the sole remedy for failure to meet contractual obligations. Honorable Chairman and members of this joint committee, the mining sector remains a major driver of growth in the Liberian economy. It is therefore essential to ensure predictability in revenue generation, employment creation, and socio-economic development to support informed decision-making going forward. This amendment brings certainty to the investment framework under the MPA currently under review. With clearly defined milestone, it is now possible to project potential revenue from royalties resulting from increased iron ore production, processing, and shipping. By 2027, ArcelorMittal Liberia is expected to ship at least 50 million tons per annum, and by 2031, shipment volumes are expected to reach at least 20 million tons per annum. This amendment establishes clear and enforceable mechanism governing shipment volumes beyond 20 million tons per annum. These increased production and shipment levels are also expected to result in expanded employment opportunities for Liberians. Honorable Chairman and members of this joint committee, it may be recalled that during one of the legislature's oversight hearing last year, it was observed that the current MDA requires the concessionaires to appoint a Liberian to one of the top 3 management positions. However, the existing NDA failed to clearly define those positions, allowing the company to present an accounting grant with more than 10 senior management roles, thereby complicating enforcement of this provision. The proposed amendment addresses this deficiency by clearly identifying 4 executive management positions: Chief Executive Officer, Chief Operating Officer, Chief Financial Officer, and Chief Administrative Officer, at least one of which must be held by a qualified Liberian from and after the first anniversary of the third amendment's effective date. Honorable Chairman and honorable members of the Joint Committee, the Community Development Funds has been increased by nearly 67% from $3 million to $5 million. Investment in education and public infrastructure have also been strengthened through commitments, including the construction of a new vocational training center in Grand Bassa County, among others. Over the years, it has been difficult, if not impossible, to ensure that the rail corridor from Ikepa to Bikena is available for use by more than one user. Although the existing NDA provides for third-party access, such access has never been realized due to limitation in the agreement's language. This amendment remedies that challenge by establishing, through the Rail System Operating Principle (RSOP) and related provision, a functional multi-user rail framework. This framework will unlock additional revenue opportunities for the government through third-party access and provide for a transition from the current user-operated model to an independent rail operator framework. Honorable Chairman and members of the Honorable Joint Committee, while the Interministerial Concessions Committee, RCC, did not obtain everything they sought, an outcome that is common in any negotiation, the ministry firmly believes that the negotiating team has done its utmost to ensure that this amendment significantly improves the existing MDA and deliver greater and more sustainable benefit to the Republic of Liberia. Thank you for allowing me to make this presentation.
The voice of ArcelorMittal Timber, the Minister of
Thank you very much.
Mines and Energy.
Thank you very
So
much,
now move to
Honorable Chairman
the National
and
Investment
members
Commission.
of the Joint Committee for the invitation extended to the National Investment Commission to form part of this hearing today. I bring you sincere greetings from my chairman, Honorable Jeff Blibo, who have already sent his excuse for not being here today because he formed part of the government delegation for the World Economic Forum in Switzerland. And my executive director also happens to form part of the government's delegation to London for the arbitration case between the government of Liberia and Weah Mine. And I have already shared our presentation with the chairman of the committee and Senator Patikwa through the soft copy also. So kindly permit me to read from the perspective of the National Investment Commission our presentation for the purpose of this year. This presentation summarizes technical and operational benefits expected to be realized by government and key concessions made by the government in exchange of those benefits in connection with entering into the Third Amendment to the Mineral Development Agreement with ArcelorMittal Liberia. Benefit number one, one-time payment to the government. AML will make a one-time payment of $200 million in exchange for all the benefits it receives under the Third Amendment. This substantial payment can be viewed, among other things, as a net settlement for trade-offs made by the government in connection with modifications of the debt-to-equity, convenience, and other provisions that benefited AML. 2. Establishment of the process for transition to an independently operated multi-user rail system. AML has agreed to a process that is intended to result in the appointment of a new independent operator selected by the government through a public procurement process effective in September 2030. This has been a goal of the government for a number of years, and it is viewed as important by third-party users such as Ivan Huaman. AML will be appointed to serve as the real operator on a non-discriminatory basis, on a no-profit and no-loss basis through the transition period. 3. Establishment of shipping milestones for AML with monetary penalties for non-compliance. AML has established milestones for attaining shipping volumes of 15 million metric tons per annum by December 31st of 2027, 20 million metric tons by December 21st of 2031, and 30 million metric tons per annum by a date to be established within 36 months of effectiveness based on an engineering study to be presented by AML. There are escalating monetary penalties as the sole remedy of the government for AML's failure to achieve these milestones. These provisions are intended to address the holistic failures of AML to meet its production milestones and the lack of any remedy for the government other than to terminate the MDA for material non-performance. The government has found this penalty too draconian to exercise. 4. Process established for AML to lease its unused railroad capacity to other users on a temporary basis. This should enable users to gain access to the railroad earlier than they otherwise could if they needed to finish capacity expansions for their own needs first. This may also prove useful for small shippers. The government will receive 30% of the net profit realized by AML on any leases of unused capacity. 5. Process established for identifying land within AML concession area for use by third parties for stockpiling and loading and unloading facilities. The process is an important step because AML to date has been reluctant to enter into discussions that will enable third parties to build the infrastructure they will need in order to gain access to railroad. Further agreements will be required once land is identified. 6. AML expansion rights on the railroad documented. The rights of AML to expand capacity for its own use up to 13 million metric tons per annum by December 2030, subject to a 1-year extension for substantial completion by that date, is recognized. If AML does not complete the project by that time, other users can begin their expansion projects. AML is granted a full right to expand up to 45 million metric tons per annum if it can demonstrate need and will commit to use at least 80% of the new capacity within 7 years. There are monetary penalties if it fails to complete the expansion within 3 years or to fulfill the usage commitment. Although this can also be seen as largely a benefit to AML, it is beneficial to the government to have the rights documented and the conditions on which AML can exercise the rights spelled out. This also provides more certainty, enabling other users to plan their projects. Social welfare benefits. AML agrees to develop and implement a social infrastructure plan that addresses concerns expressed by the affected communities in Nima, Bone, and Grand Basso counties, respectively. The third amendment includes specific projects. There are special monetary penalties benefiting the Community Development Fund if the timing and funding requirements for this plan are not met. AML will contribute US $5 million annually into the Community Development Fund. At least 50% of the annual contribution will be earmarked for investment in communities within the concession area and the remaining in adjacent communities in the affected counties. The third amendment creates a process for developing a government mechanism that is responsive to local development agendas. The management employment milestones have been updated since AML had not complied with the existing milestones. Other fiscal benefits and trade-offs. In general, the parties modified some minor fiscal items and extended many of the stabilized tax terms for the existing NDA for the next 25 years. The government made trade-offs on some major fiscal items which, if accepted by AML or enforced by the government, who have meaningfully increased the government revenue from the project in exchange for the one-time AML payment and AML's agreement not on the real estate. Income taxation. The third amendment extends the concessionaire 25% corporate income tax rate for AML instead of the statutory 30%. Debt to equity ratio. It is the government's view that AML has been in long-standing and material default under the 3-to-1 debt to equity ratio under the existing MDA provision. This default has serious implications for the revenue of the government's 15% equity stake in AML. AML disputed whether it was in default. The third amendment essentially eliminates AML past default and gives it wide latitude for using debt financing going forward by eliminating most of the effect of accumulated losses from the definition of equity and purposes of the MDA. Annual surface rental payable by AML changed from a fixed rate of $300,000 to a rate payable under the money pool and revenue pool. Annual payments by AML under the MDA have been indexed for inflation. Late penalties imposed. A schedule for monetary penalties is established for failure to take actions by deadlines under the MDA, in addition to penalties described elsewhere. This provides the government with a remedy shock of termination for these defaults. Put a Buchanan operating framework document. The third amendment does not make any significant changes in AML's port operations, but it does provide for more detailed documentation of those operational proceedings through a port operations agreement to be entered into between the National Port Authority and AML. Establishment of more detailed process for third-party access to the railroad and capacity expansion on railroad. This was a key objective of the government from the outset. The RSOP spells out in detail the process of new users to apply for and be granted access rights to use the railroad and expand the capacity of the railroad to meet their needs. The government has sole description of approval to approve access and capacity expansions with input from the Joint Management Committee comprised of users. Establishment of procedure for selection and appointment of independent rail operator. The RSOP spells out the process by which the GOL will select and appoint an independent rail operator through the public procurement process. The selection is made solely by the government based on qualification criteria established in the RSOP. Establishes rights and duties of users on the road.
You got 1 minute to summarize.
Yeah. So provides let me just go to the right. So under the RSOP, what protects the government's interest under the protection of the government interest under the RSOP require government approval of any amendments to the RSOP. Require government approval of certain policy decisions by the Joint Management Committee. Government, through its non-voting membership on the JMC, can initiate proposals at the JMC. Government members will act as chair of the JMC meetings. So, honorable senators, honorable chairman, and distinguished members, in summary, the Interministerial Concession Committee has negotiated this concession in good faith, fully cognizant of the needs of the Liberian people. As such, I submit on behalf of Chairman Jeff Bligo. Thank you.
Bligo.
Thank you. Honorable Chair.
So we move to the Ministry of Labor.
Honorable Chair, distinguished member of this committee. As you are aware, the Ministry of Labor is charged with responsibility to administer the affairs of labor in the Republic of Liberia. For the purpose of this hearing, we will highlight key points in this third amendment that the country and the people of Liberia, including the community, stand to benefit if it is ratified by you, which by God's will we know you will do, because it's all in the interest of every one of us. Within this amendment, it provides some of the benefits that you will see in the amendment includes job and liberalization management. Under job and liberalization management, the amendment provides that within 1 year of ratification, at least 50% of the job that will be provided by AML will be given to Liberians. It also provides that within 1 year of a ratification, if that is done, at least one of the top 4 managerial positions, which include the CEO, CAO, the CFO, and COO, will be occupied by Liberians. It also provides that absolute preference will be given to Liberians in terms of job that Liberians are capable to do if that vacancy exists. That means the inflow of foreign nationals that we all continue to complain from, the graduating from, bringing people from other countries to come and do a job that Liberians are supposed to do. So this provision also stands to benefit all Liberians if this amendment is ratified. You will also see in the amendment that there will be technical and vocational training school constructed in Grand Bassa County. It also provides for giving support to people from the affected communities. I mean, Liberian, Bassa, and Grand Bassa County. Residents of those affected communities, the amendment provides that if it is ratified, there will be priority given to them to train them to become geologists and mining engineers, since their focus is in those directions. So that means the affected communities that have been crying over the time, they will now stand to benefit if the amendment is ratified by this body. Again, the reason why we from the end of labor, we feel it is necessary for this body, the oral body, to ratify this amendment is that our citizens continue to cry for a job. They come in to be a vocational training school. The fact that the amendment provides that there will be opportunity for Liberians to go abroad and learn. There will be opportunity to sponsor people from the affected community annually to go out and acquire knowledge to come back. It means they are graduating from importing foreign nationals to come and take lucrative salaries and benefits that they carry out there and develop their own area, but now will be training our people who will be capacitated to do the job. Air proceeds from air proceeds from that will be right in country and will develop our economy. Honorable Chair, a member of this body, I am pleased to let you know that the summary of my presentation has ended, but this is my recommendation. I will recommend that while it's true that this agreement is very much in the interest of the country, as you all are aware, we also, on the basis of collaboration, we also depend on you upon ratification. The team continue to work together. Your oversight should be with us as implementing agency and institution to make sure whatever existing or placed in this amendment can come to fulfillment so the people of Liberia can benefit. But on the whole, the amendment is good and we're quite sure that you will to rectify. Thank you.
Thank you for your presentation. Now listening to you. You come from okay. So asking to make a commitment to it, people will come for you. To make a commitment to the poor abroad.
I, Anthony G. Myers, Deputy Minister of Finance and Fiscal Affairs,
do hereby swear
do hereby swear
that the testimony I am about to give
that the testimony I am about to give
and to my recollection
is the truth,
and nothing but the truth.
and nothing but the truth. So help me God.
Yes, sir. Witness is qualified, sir.
Thank you.
Mr. Chair, our guests from the executive have given us some very beautiful speeches on our oath. Can we get a copy of these speeches so that we can form part of our oversight for compliance later?
You brought a copy of the speeches? We are doing that, investment or.
Out of those who made presentation, do you have them soft copy or hard copy for our file for future reference for oversight?
Yes.
Yeah. Okay, so please send it to the chair.
Okay, thank you. I'll submit my soft copy to the chair.
You don't have your time. Keep writing time.
Thank you very much, Honorable Chairman, and my apologies to the committee and the Senate for not being here from the start, because I didn't know the communication was routed through our IMTC chairman. I just saw it when one of the officials here called me, so my apologies again. So I sit in for the Minister of Finance, and I'm the acting minister because he's away on national duties in Switzerland. And the Minister of Finance is an integral statutory member of the IMCC. And the Minister of Finance was also fully involved with the negotiation with ArcelorMittal Liberia. And one of the most intense part of the negotiation towards the end happened to be the fiscal provisions. The Ministry of Finance, assisted and supported by the Liberian Revenue Authority, was interested in ensuring that the fiscal provisions in the proposed third amendment mark significant improvements on all previous amendments, including the existing one that is due to expire in 2030. So even before Oral Dillon made the request, I've already flashed the document I'm about to read from to some of the members whose number I have. That includes Senator Tyler, Senator Twain, and one other person. So I hope you can please extend my hand in that regard.
Please send it to the chairman.
I'll put it in chairman.
Okay, then I will get the chairman's number and send it. Okay, thank you very much, Senator. Okay, so the summary here provides a series of revenue provisions from the Liberian Revenue Code. And what were the changes made in the proposed amendment compared to the existing one? So I begin with income tax, corporate income tax. Under the Revenue Code, the minimum concession you can grant to concessions emitter is to lower the rate from 30% to 25%. So that has been in existence, and also in 2024 we introduced the amendment to the corporate income tax for concession, mining and agricultural concessions, which require them to pay 2% of their gross revenue in advance on the quarterly basis, while waiting for the end of year or tax analysis or income and profit analysis. So they were subject to the 25%, but not a 2% presumptive. So as a result, we had to wait to the end of the year for profit to be declared before we get taxed. So under the new regime, the 25% were retained as part of the negotiation, but the 2% minimum tax was introduced. A presumptive tax was introduced. But more than that, we also introduced what we call a high yield surtax, and that's about 5% of the corporate income tax. Meaning, in the event where iron ore prices go above what we projected along with AML at the beginning of the year, when the actual prices during the year exceed that, that is considered super profits or windfall revenue. So that windfall revenue will therefore push the tax rate now to 30%, which means an additional 5% will be levied. In addition to 2% on the excess, on the margin. Say price of projected at $100, iron ore price goes to $150. 2% of that $50 will be taxed. Then the applicable tax rate for that year will be 30% instead of the negotiated 25%. Then interest deduction. Under the current regime, META can deduct 50% of their interest from gross revenue or the earnings before tax and interest deduction. So what that does is that the base profit or the base revenue that is subject to taxation is reduced. So under the new arrangement, in fact, the revenue code requires 20%. So through the negotiation, we settle on 25% instead of the current 50% of interest deduction that is applied. So what that means is that more resources are left for tax purposes. Instead of 50%, interest deduction is now 25%. And then depreciation rates. As it is, all assets are depreciated on a straight line basis. But under the new arrangement, depreciation will go straightly by the revenue code requirement, where assets are distinguished between tangible fixed assets and other type of assets. And even among the categories of tangible fixed assets, the assets are depreciated on the asset-by-asset basis. For example, buildings and railroad track, for example, or installed plants, those are different type of assets, so they will be depreciated differently, rather than just a straight line and single rule for all type of assets. And then loss carry forwards. The revenue code requires 7 years. 5 years, sorry, the new amendment requires 5 years. Negotiation, we actually pushed for the 5 years, but the negotiated rate is now, carry forward period is now 7 years. And this was mainly in consideration of the type of industry. The type of industry, because this is where heavy equipment are involved. The period between acquisition of those assets, installation, and putting into production, it takes significant time before actual production can happen on the given borrowing. So we're flexible in that regard by carrying it from 5 years as is the code to 7 years. Then royalty. One of the main issues that have bothered all policymakers has been why META has not been determined or declaring. Okay, no, sorry, this is royalty. So the current royalty rate is 2 to 3% based on what is discussed. The revenue code say 4.5%, and so the new proposed amendment went by the revenue code requirement of 4%. And the payment initially was done at 45 days after shipment, or 45 days after the end of the quarter in which the royalty is due. But this time it starts with shipment, 30 days after the date of shipment. So if they ship today, January 21st, February 20th, we expect the payment. And then there is a resource rent tax. The resource rent tax is pretty much in application in this agreement the same as a high yield tax, which is a 5% additional CRT during the year where there is a high yield. Surface rental. The revenue code in section 704 have various provisions for surface rental. There is 20% per acre for exploration, $5 per acre for license for the first 1 to 10 years, and then $10 per acre for license contract from 11 to 25 years. So meaning the 25-year period of this agreement, the surface rental will be staggered. If META is to go into any new exploration in any of the part of the concession area or anywhere else, that will be the staggering of it. The first part for exploration only, it will be 20 cents per acre. Then for 1 to 10 years, that will be $5 per acre, and then after 10 years, that's 11. That's $10. Import duties. I will speak more to import duties as a separate thing from this, so let's skip that. Then custom user fees. Yes, they are subject to the 1.5% of CRF value at all Liberian ports. This was not included explicitly at that because it was just capped at $10,000 per item, but now it's 1.5% of CRF value. Then GST, as it is, they were exempted from GST, but right now they will be subject to all GST or all items as required by the LRC, except those things that were exempted specifically in the concession agreement. Dividend, okay, I was talking about dividend earlier. So as it is, there is no provision for dividend in the current agreement, but the new agreement, proposed agreement, requires for AML itself 3.5% of dividend on their profit. Third parties, other than the government and GOL, other than the government and AML will be 5%. So 3% royalty charged to AML profit, and of dividends, then 5% on other third-party dividends. And this argument, we put it because dividend is an income that is earned in Liberia. So our law requires that any income earned in the country should be subject to income taxation. Interest, 5%, the current agreement says 5%. Now this is for the distinction between resident and non-resident in our code as to what interest can be charged on certain services. So the law now says 5% for residents, so META Liberia being a resident. But this doesn't apply to META holdings, that means other affiliates outside of Liberia, but it's only ArcelorMittal Liberia. And then services. We know ArcelorMittal procure services for waste from many sources, domestic and external. So under our new provisions, 6% for service providers, they have to do withholding of 6% or whatever fees they pay to service providers. The capital structure. The capital structure, meaning how much of debt compared to overall equity you will accept, is 3-to-1. As it is, there is no specific provision. In our negotiation, META was proposing 4-to-1. We say no, 4-to-1 will mean a greater interest deduction on debt, which will depress our available revenue. So debt to equity ratio negotiated in this contract is 3-to-1. And I'm sure if the Ministry of Internal Affairs, of Mines and Energy are presented, there was an increase in the Social Development Fund from 3 to 5 million. And I was talking earlier about the custom provisions. As attachment 5 to the agreement, there's a list of more than 20, up to 25 items that are subject to import duty adjustment, in some cases waiver. But one significant change we made this time is that all of the items included on the list of adjustment or waiver are investment related, things that will be needed as part of the build-up process, not items that are brought for regular use, whether by employees or management or others. So a typical example is on number 18. Education supplies is included as materials for custom duty exemption or negotiation, but we excluded stationery. So what this means is that stationery as an indication or process for the kind of commodities that they had exemption on in the past, like toiletries and those regular things we find in our merchandise, will no longer be subject to duty waiver. And we also included further in this discussion, in the negotiation, it will also be seen is that there were provisions, it's not in my note, but I can reference it in the contract, that the first port of call for energy use for meter will be our public grid. To the extent that wherever they are operating, whether in Nimba, Bong, or Buchanan, to the extent that there's available capacity on the public grid, meter will be required to use that as a first port of call. They are not prevented from doing self-generation, but where there is capacity on the public grid, it will be required to buy from the public service provider. So those are just some of the improvements we made in the fiscal and other provisions. So with that, Honorable Chairman, I submit.
Okay. We were going to revert to the Justice. Oh, okay. So Justice, please take the stand.
Honorable Chair and members of this honorable committee, much has been said. I would not want to bore you with additional information. Justice Ministry just took cognizance of the fact of Article 3, Section 2C of the agreement, which require that the terms should be fair and reasonable. And we think from everything that has been said, the new amendments that are made to this agreement, we consider them to be fair and reasonable for Liberia. And so at this stage I will submit, and we'll look forward to any legal questions that we'll need to answer.
Okay.
So that's short by the Ministry of Justice. So all of the witnesses have completed
So just two questions, I'd like to know from
testimonies.
During the period that EMS mine, what's the quantity of fuel that has been mined? That's one. What has been for the investment, and then how much revenue has been generated.
There's a question just coming from Mark become the Senegal.
Anybody who wants to ask? You got information you get all better? No.
Our Chairman and distinguished member, with respect to the question as it relates to the quantity of oil being mined since ArcelorMittal started lifting oil, the data is there, but we don't have the exact figure yet, but we will furnish the committee with this before the end of the day.
Do you also have an idea on
Investment up to this point? So there are two questions. The total investment, the volume of oil mined and exported, and how much has been generated from what is exported.
So, I'm sure, for us, the information is available, but it's not readily at hand. Because
It's not readily available.
No, it's available on Verifast, but readily at hand in here. Because this is not something you can guess.
So you're not readily available.
Okay.
So you have furnished the committee with the information?
Yeah.
You probably have to have the whole
The first question.
So Senator Jala.
Just one question. The first one is an observation. Usually on an agreement like this, we will have amendment and restatement so that we have the picture of the whole agreement. Unlike yours, you just tell us the amendment. What happened to the rest of the agreement? How are we going to monitor the rest of the agreement? Are we going to have two separate agreements? That's the first question. I have the other two questions if you answer these.
Thank you, Honorable Senator. With reference to the amendment, as you know, the agreement was first signed in 2005, and two separate amendments have been made. Those amendments were made without restating the entire document. So we believe that it is along the same line that this third amendment was made. So normally what we do is to have an unofficial version that blends the changes made in the agreement versus those specific parts of the agreement that are not amended.
Yes, sir. Unfortunately, this is unacceptable because 10 years ago is not 10 years later. I was not here 10 years ago. We have a organization in drafting laws. This is a law that we drafted and it's an agreement. So there's no reason why, why you did it last time. You should recapture everything to give us a direction into the future. Right now, we don't even know what you're doing or what you have been doing. How do we monitor all of that? So there's a need to have some understanding of this, that you will recapture, have an amendment and restatement of this law. That's my first question. I'll give that to the decision of the Senate. My second question, how long is the contract, this concession? How long? Did you allude to automatic renewal at the expiration of this? Are you alluding to automatic renewal?
Honorable Senator, the original provision that is made for the contract is that the concessionaire shall have the option for an extension, 25 years extension. So as this initial one is ending in 2030, they are exercising our rights for additional 25 years.
Yeah, but it's subject to terms and conditions, At the end of this period, it's subject to terms and conditions. So it should not be automatic. Am I correct?
Unfortunately, it's almost automatic. So the only term that is provided for is that they should have a showing or from the feasibility report that there is additional iron ore in the ground.
That's my next question I'm coming to. But there should be no automaticity in contract agreement, because there could be something very miraculous that will happen. Supposedly you find that the price of iron ore has doubled or tripled. For which reason why you may want to add some, information to that agreement. You're just going to say it's automatically renewed. So that is also unacceptable. Let me ask you my last question. I know you have decided on these things already before coming here. Now let me ask you my third question. My third question is, and my last question. How many megaton deposits in this demand market? How much has been exploited so far at the time of extending this contract? And how much will be there when it's automatically renewed? Do you have the analysis?
Honorable Senator, the analysis is available because the amendment is contingent upon that analysis. Because what is stated is that before an extension is done, for the contract, there should be a feasibility report. And the feasibility report will state that there is additional iron ore there, which is the amendment is contingent upon. Unfortunately, we cannot readily make it available now. He's just about to make it available. Yeah, he's just about to make it available.
Thank you, Honorable Senator. As a basis for the discussion, and this discussion of the amendment started several years ago. The former Minister of Mines
in 2019 approved a feasibility that was submitted by ArcelorMittal with the following characteristics of dry metric tons. Tokabe, Gangra, and Yeleton indicated was 689,489 million. 689,489,000. And then on the inferred was 1.9 billion, totaling to more than 2.6 billion tons of iron ore.
No. That's the
resource.
That was there.
That was there.
2019.
Yes. And if
that assessment was done by ArcelorMittal.
Yeah, it's done normally by an independent group, because normally these groups that will do this sort of investigation, it is based on such information that investments are made. So you have third parties that have specific legal obligation to ensure that the data that they present are genuine and individuals can invest in such activity.
So, Mr. Chairman, please follow up. So, according to that report, who was the independent group that did that assessment?
I'll be able to get back to you before the end of the day, because I knew we would definitely have the figure in terms of volume, but I can give you that before we leave.
But you're reading a report.
The specific section. I'll just give that to you before we leave.
Yeah.
Well, the way you're coming from,
Okay, so now you have the floor.
Thank you. Thank you. Distinguished gentlemen, I'd like to I think we'll be having a good time. Thank you, Mr. Chairman, and to our witnesses on the stand. Let me welcome you again. I sat here and listened to some of the presentations that clearly articulated the views of the executive, some of which were full of admiration and praise for the agreement or the proposed amendment. I want to use the first half of my time to just lay out 4 key issues that we see wrong, and you take notes on that. It will be followed by our questions, and then you can respond. The first issue that we have with this entire third amendment is the issue where Senator Jala picked up from. You have proposed to us a 25-year amendment.
Yeah, I don't know who you have everybody. Senator Saros, introduce yourself.
Thank you, Mr. Chairman. My name is Anthony Cyrus. I'm representative of Beaufort County in the Liberian Senate. I'm member of the Senate leadership. So I have oversight over the security sector, that is defense, intelligence, security, and legal affairs. And I'm also a ranking member of the
Thank you. Not that.
Oh, yeah, not that.
No, how do you
introduce myself?
Introduce the player concern.
The chairman, distinguished senators and Senator Prince K. Moy, the Senate Standing Committee Chair on Ways, Means, Finance, and Budget, and the Legislative Caucus Head of Bond County. Thank you. Thank you. I hope this was not a clever tactic to take me off so that I can be back on point. But I will start from where I left. To the members of the INCC, today you've given us a document to ratify for 25 years. But in essence, it is not 25 years. You've given us a document under the guise of 25 years for actually 15 years. Automatic, extension by 25 years, by 2050, will give the mountains in Nimba to ArcelorMittal for 75 years. But you are here today giving us a report that we are going to ratify this document for 25 years without legislative approval. The structure creates the possibility of even 100 years. That's what the document says, because from then onward, rollover will be dependent on good faith and feasibility study. So once Mita come and tells you, I will say, I want to continue another 25 years. And I think you should take note of that and respond appropriately. Without legislative ratification of these kind of documents, where will be our powers as legislators? The legislature will be surrounding all powers in totality to the executive branch of government to do the will of the people. And as the people's representative from Nimba County, I don't think that would be appropriate for the Senate to allow the clause to persist. The second issue of the four is the absence of termination clause and termination rights for non-performance. It is only in the agreement that failure to meet production, shaping, expansion, obligations, or even social benefits for affected community. The only thing that you will do to ArcelorMittal is to fine them. To the extent whereby those fines are spelled out. So when you will be doing that, people will be violating, people will be depriving our people of the social benefits and then pay smaller fines. Because to develop and spend money on our people will be much more expensive. So this is a clever attempt again. And if this clause came from the company to perpetuate our people in the kind of way they are doing, violating the current MD. And the reason this is important, and I will come there, we all are in agreement along with ArcelorMittal that they have violated the terms of the current MD, especially in terms of social benefits, hospitals, clinics, roads, etc. And so this is something that I want you to look at. You cannot have, this agreement does not meet the minimum standard of a renter and a landlord. No termination? No, that would be unacceptable. The third concern here, before moving to the question, will be the community infrastructure obligations are not enforceable. Why? Even as bad as it is, the current MDA that has been violated by ArcelorMittal has in Article 8 and Article 10 and other articles enforceable developmental and infrastructure benefits for the communities, for local communities, for affected communities. In the new and current amendment that you are proposing to us, they remove enforceable social benefits and obligations entirely. And then it stated, it replaced it to say 3 months after ratification, a social obligation and infrastructure plan will be made by the government and the company. And if they fail to do it for the first 3 months, they will pay a fine. If they fail to do it for 1 year, they will pay a fine. If they fail to do it for 3 years, they will pay fines. Are you reading? Are you seeing what I'm saying? Why is the social infrastructure plan not an appendix or an addendum like the RSOP? You brought a real operating principle here, as an appendix to the agreement. What's wrong with making a social infrastructure plan and obligations and attach it to the agreement for us to ratify it so that we can know what the affected communities will be benefiting. This is one of the egregious omissions from this particular amendment that you have given us. You've already violated all of the benefits that you should have given our people in the current NDA. And that's why we've been forcing up and down here. And they admitted it on over where you sit. And then you go and omit them again? No, that is unacceptable. And we need explanation for that. The fourth and the last one has to do with the flat lesson fee and fiscal imbalance. You wrote in the agreement and accepted from the general, they will pay $500,000 as flat money fees. Senator Jara was trying to touch people and he didn't go for it. So we all don't know how to predict the future and the future of commodities or natural resources. Why this amount is not indexed based on production, based on pricing? By 2031 onward, all money lesson fees are replaced at a flat annual rate of $500,000. The fee is not indexed to production, it's not indexed to volume, it's not indexed to land area or inflation. So if ArcelorMittal goes on the money market today and take a $1 billion loan and decide that the entire concession area, all the mountains will be mined at the same time, yes, they can do that. They will pay $500,000. And within 10 years, the entire mines in Lima will be depleted because we'll be taking $500,000 without indexing it, without tying it to land mass, without tying it to volume. That is despicable, and we need clarification and explanation for that. Then I move to my questions so that you can just take note on all. If you forget to answer any one of them, I will remind you. Is there any document, by the way, to also show to us, given the egregious violations, we need to know who will hold responsible for our roads, the environmental pollution and all these things, the non-compliance in building schools and hospitals and clinics in the current MDA, because ArcelorMittal, Switzerland AG that we've been operating with, are sold or transfer all of the rights and liabilities, whatever it is, to ArcelorMittal USA LLC. Do you have document for that transfer? And does that document has in it an agreed liabilities, breaches, and violations that they are passing on to ArcelorMittal USA? Because many of us will go to court in the end. We are not going to sit here and people mine, in our area, dig big holes and leave us here, and then they think they will just walk away by bringing another agreement. No, it will cause us to go to court. We will go to court. So we need to know who to hold responsible. Say ArcelorMittal Switzerland has turned over to ArcelorMittal the USA. We need to know and see the document. And what's more worrying is that you should also answer me here. Who were you negotiating with IMCC? The agreement between ArcelorMittal AG and ArcelorMittal USA was signed on December 9, 2025. This MDA in Brian was signed on December 20, 2025. 11 days after the both companies did the transfer. So who were you negotiating with? Do you even know your new company that took over? These are things that we need answers to. There is no review clause as far as my knowledge and my readings are concerned within this agreement. And if it is there, please tell how is it? A representative called me last and told me, oh no, they didn't restate that because in the old MDA. We are not going to be dealing with the old MDA as of 2031. Why this new agreement cannot have in it a review clause? People fought war and came to the Capitol building. Many of them were still rebels. When they passed the ArcelorMittal deal in 2005, guess what they did for us? They put a clause in there for us to review it. But here we are, democratically elected government with all the erudites. We are removing review clause from in an agreement to not give future government legislators, president, the chance to have a say in how the natural resources are mined in this country. Why can't we put it in this agreement? Is there a review clause? So that's it. Mr. Chairman, you've given me a lot of time. I know I've raised a lot of questions. I will pause here for a while and listen to your input on some of these questions, and then I will make some follow-ups if there are time.
Can you please respond to the Senator's question?
So,
Senator, we will try to answer the question, all of us. And please remind us where we fail to answer any one of those questions. So we'll take them, all of them, not in the specific manner as you lay them out, but we'll try to answer them as much as we can. I would take the part with reference to the flat license fee, the mining license fee that we talked about. Okay? Now, the mining license fee in the current MDA is $50,000 US, one-time payment. And that is for 25 years. Meaning ArcelorMittal, over the period that they have operated, has been paying on an annual basis $2,000 US per year. And so for the 25 years, up to 2030, ArcelorMittal has had to pay only $50,000 US, one time, not every year. Under the current agreement, at the end of what agreement we have with them right now, by 2031, ArcelorMittal would then pay on an annual basis $500,000 US every year. So when we say within 3 years ArcelorMittal will finish all of the ore, we don't believe that's possible. Because for the ore that is available in ground right now, if you were mining up to a maximum of 30 million tons, you would be more than 80 years. So, yes, there are other taxes that are paid, but the mining license fee is not the only revenue that we get from ArcelorMittal. So that fee, in fact, ArcelorMittal will be one of the first companies that will be making that payment if we do not amend any of the other ones, or we do not have any new mineral development agreement. The rest of them that we have, they have stabilization clause, so even if we introduce $5 million US as the annual license, they will continue to pay what they have in the agreement as it stands right now. And I would just want to add that this amendment tries to amend specific section in the MDA. The MDA is the MDA as it is. Unless those specific part has been amended, it holds. So if there are termination clauses that are not amended by this specific provision, those termination clauses carry on. So it is only these parts that we have changed that are to be added to the new one. So as I said before, in the first amendment, 3 or 4 different sections were amended. It did not give us a new agreement. It is the same agreement, and only those specific sections that are being amended here that are going to apply. So there are review clauses in the agreement, and it calls for review every 5 years. Now, when it comes to amendment, what we already have is not a good agreement. What we have done is try to get the best out of what we have right now. And so, in negotiation, it's always a give and take. We would have asked for everything, and the company asked for more. It was not only us. So, we tried to get as much as we could get. The Minister of Finance laid that out, and our colleague would lay that out. So, there are review clauses, there is review clause, there is termination clause, and the payment is not the only remedy. What we have done is, we gave, the agreement has been hard to enforce. We've tried. Some of those things were not enforceable because the first thing that you need to do is to give a notice of default. And it means if they do not cure that, you then go on to termination. It's like to tell your son, we'll kill you, I will kill you if you don't sweep. So that's the only, most of the time, that was a major remedy. And it's not easy for a minister to terminate an agreement that has jobs, that has revenue implications and everything. Or to terminate and then go to arbitration and keep the investment in a problematic manner. So we believe that some of the things that will help to enforce or ensure compliance is not to only have termination as the only remedy, but to have penalties. But yet, termination is still available on the table, and that has not been taken off.
Mr. Minister, I will interrupt you there because this is my time so that I can clarify something. This amendment is not just an amendment. It is enshrined in here that the MD was going to be restated and consolidated. Yes, it reads. I will get started on page 2. It says, whereas the following series of negotiation and consultation, the government and ArcelorMittal have agreed to further amend certain provisions of the current MDE, which is the third amendment. Listen, we should get it right. It being understood that the parties have agreed to restate the current MDA in order to incorporate the third amendment hearing and to enter into a full amended and restated MDA, incorporating all such changes into a consolidated document. We should have brought forward all of the, when you amend, that means the old MDA, the new MDA becomes a consolidated document. And this is not a restated and consolidated document. And this amendment as of 2030 will be the new agreement. So when you did, you just took a few things from the old MDA that you were not satisfied with IMCC. Thanks to you for some of the improvement. Yes. But it didn't restate. Such an Article 8 that was clearly talking about roads and cleanings and bridges and what have you, they were omitted. They were not restated here. So this is my problem. So, you know, without further debate with you, I don't agree with you that clauses in the old NDA will still be used in 2031 in this NDA. They didn't restate them and they didn't consolidate them. You can move forward with another question.
In addition to what my colleague from the ministry was just explaining with respect to the flat license rate, there was a question raised because the volume of production has increased. So why should the fee still be like this? You know, fees, more especially the license fee, is not like royalty. That there will be an increment in fee with respect to the volume. But this is a fixed, license price that is being given on a specific time period, which is the 25-year period. Like he just explained about the $50,000 that was paid by ArcelorMittal. If you aggregate that, over the number of years, it will be $2,000 per year. There was no temper with it. But this agreement is saying that there should be an improvement on it. And this is the reason why every agreement is subject to an amendment, because it depends on the prevailing circumstances, on which the operation of that particular company is moving. So the issue of the license fee does not necessarily have to go along with volume.
What's the information?
My information here is that just so we have the hearing, it is very important that the senator raised. Going forward now to the page 2,
on the preamble of this document. It said the third amendment herein and to enter into a fully amended and restated entity incorporating all such changes into a consolidated document as soon as possible following the signature of the third amendment. The signature of the third amendment was obtained. It is following the ratification by the legislature. So before we ratify that agreement should be before us. That's the information. Thank you.
Honorable Chair.
You want to respond?
Yes.
Okay.
That was just one of the points that I was going to, that this is not a final. This is the amendment that we're discussing, and then it will be restated, consolidated, and made one document. So this is not a final. It will definitely be restated. I just
Are you saying after we ratify it?
So we can get something clear. You said this is not a final document?
No, this is not the one for signing. His point is that we said we're going to all right, this is the third amendment. His point, as I understood, is that why are the points in the second amendment not included? Why are they not included?
But Mr. Martin will come about this, so we can go and come back. But what are we ratifying?
I'm just honorable saying to him that his points are taken.
No, that's my question. What are we ratifying now?
The third amendment.
You said this is not final.
Honorable, his point of the restating and consolidating will be done.
So we ratify, then you go consolidate and sign it, approve it. Is that what we're getting from you?
Wow. So I think the point the senator that you are making is taking is understood. So it's a case of, from my understanding, procedure and availability of information. Okay, Senator Jala, for example, mentioned that at the time of the first and second amendment, he was not here. And most people would say that. So if it's an appeal I'm making. If the situation is about having the previous amendment with us to compare what is being amended.
No, that's not the issue. What are we discussing now for possible or likely ratification of our vote?
Okay. The legislature had previously, in 2005, signed and ratified the MDA. Then that MDA went through 2 subsequent amendments.
That first period finished.
Okay.
And the second period coming in 2010, right?
I agree, Senator.
We're coming to ratify something that will take effect from 2021.
Is these changes that will take effect new?
So we're coming to ratify something that takes effect in 2021, when it's actually not before us yet.
No, okay, let me give an example, Senator, with the appropriation that we familiar with.
Okay.
The Constitution, for example, or the Liberian Revenue Code. Since 2006 and since 1986 and 2000 respectively, these documents are all of us.
This document and we'll vote on it tomorrow. Why does it take effect?
These changes, these changes are being introduced.
This document, the whole document you brought it as third extension. If we, for instance, vote on it tomorrow, so we ratify it, when does it take effect?
No, you see, when you put it that way, Senator, it becomes difficult for us because there are some provisions, the MDA is still ongoing.
No, sir. Mr. Minister, we have an existing second extension until 2029, until 2030. It is not in dispute. It is upon which ArcelorMittal is operating.
So, Senator,
this
let me make the point I want
this document you brought before us now.
Senator, the point I want to make is that amendment does not vitiate the entire document.
You listening to me too?
I was trying to respond. You not allowing me. The document
Mr. Minister, please. Let me, at the onset of the discussion, we said that let us talk one at a time. If a senator is asking a question, give the senator a chance to ask a question, then you respond. At the time the person is responding, you, the senator, you call them to order. When they start, you say you report. If all of us engage each other, then we will not understand each other. So sorry, sister. So, Senator, are you satisfied with your concerns?
No, so let me,
even though it's not your time.
Yeah, please.
Enough.
Also follow up. Okay, so I will wait from
you. Will wait for time. Okay, so.
The General, I know it's not my time and not on the floor.
Yeah.
But we have to respect our council. We sincerely irregular. And we try, we are a government. If there's a problem, we fix it. We see problem, and we try to dodge the problem. All of us can make this state on this big oversight. The document said you want to consolidate everything in one. If you didn't do so because of oversight, yes, it is the government. It's up to tear everybody down. You know what I'm saying? At the end of the day, we all want to gradual people for the country, and so on. So it's irregular. There's a little problem there. Let's try to fix the problem. That's why you listen to the point. So that we all come together and fix it. That's why we are in government.
Intervention succeed.
Okay. So let me go to the next one, the social infrastructure and social obligations. Why is it not in the agreement? Why is it not an addendum or an appendix to this agreement? Instead, it will be 3 months after ratification, when they knew that they put their own RSOP there as an addendum or as an appendix. Why? So our people should wait for the goodwill of the government and ArcelorMittal in the future before knowing what it is happening for them.
Honorable Senator.
Please use the mic.
Honorable Senator, in answering the question that was posed by Senator Dillon, so if Article 7, which is on page 42, talks about, speaks about the social corporate responsibility of the concession to the people. It speaks about the $5 million that will be provided and ways in which the communities can benefit from this amount. If you look through A, all the way going down, it speaks about the amount that will be put into escrow account, the communities that will benefit, and so on. So it is not completely taken out.
This is a public hearing. Madam Minister, that was one of the meat that we're going to go through if you answer the social infrastructure question. If this is your answer, then we are learning even where I wanted us to learn. You are actually reducing the monies that you're giving to the county in the current MDA by $1 million.
Yes.
Why is that? The current MDA gives $3.5 million to the 3 counties. This amended MDA is giving $5 million according to the increasing in value, we increasing volume, we increasing export, and you increasing it by just $5 million. But that $5 million, you are actually just giving $1.5 million in addition. You divide it into 2. You take $1 million that you used to give to the 3 counties without your intervention, and you say $2.5 million will be used by you and the government through an established committee, leaving the 3 counties on expenditure now to $2.5 million. So you are reducing our benefits that we used to receive per annual to actually about $1 million. So what we are saying, in addition to, in addition to all of these things, you were given the $3.5 million, but Article 8 and other article also suggested things that should be done
You cut all that up and you hit it on $1.5 million. Are you getting me? And that's why I'm concerned about the social obligations. Because they say if they don't do it, you got nothing to do, then they will pay small fines.
Okay, so respond. Can I hear you respond to the senator? Senator, that's the last question.
Yes. The plan that we talked about, most of the time we tend to make decisions and plans for people without their intervention or without their input. And for that reason, some of our plans do not solve the problem that our people experience. And so the discussion between the government, which represents the people, provide that means by which input from the community can be taken into account to plan social interventions in the community. So it will not be left with the company alone or be left with individuals at the IMCC negotiating during that particular period to determine the best value to assist our people. And that's why there is an obligation and a time frame to come out with plans that will affect the community. That is the principal reason. And we did not want to make plans for the community without even being able to talk to or listen to or have interventions from the community.
Mr. Minister,
in terms of
but
in terms of the amount, in terms of the amount of 5 million increase from 3 to 5 million, I say sometimes we tend to benchmark 3 million on the initial MDA. The initial MDA had production target beyond what ArcelorMittal has normally shipped, between 3.8, 3.5, rarely shipping 5 million every year. It had obligation to ship up to 18 million tons. 18 million tons when the 3 million was injected into the current MDA. So an increase up to 5 million has now been negotiated. We wanted more. We wanted more. Now, when you come to the split, there is something called the fence line community. Those communities that are closer and those communities that experience the inconvenience of the mining activities. For instance, people in Buchanan will experience the noise of the train, just like in one county. People in the mining area of Tokade, of Yellowton, or nearby will experience the sound of the explosive. And these are the communities that will easily go and obstruct the activities of the company. And so the committee thought to say, look, through all of the networks that we have, all of the provisions that we have, the local government infrastructure, let's put half of this amount aside so that these people will receive specific attention from this amount of money. That money, that half of the fund of the $5 million is targeted specifically towards those that are in what we call the fence line community. Then the rest of that money is distributed to the rest of the county.
So I hold you right there. So the rest of it used to be how much?
2.5 million. No, initially it was 3 million to the county in general. Nothing specific to those that are in line.
I got you, and I commend you people for thinking about the defense line communities that are benefiting directly in this one. But you used to give 3 million directly to the counties. My point is you are now giving them 2.5. Let's agree on that you reduce it by a certain amount.
Yeah.
And so all you're doing now, your production has increased. Your production has increased. So you only gave me $1.5 million in addition. There are certain facts that I want us to establish. I'm not trying to debate with you. I'm not trying to tell you that the money you should have negotiated for $20 million. But let's establish the fact. The monies that are going to the county now been reduced. The ones that you are adding up is just the amount of $1.5 million. How is it hard to agree with me? Okay. It's a fact. These are numbers. I can lie, you may lie, but numbers don't lie. Yeah.
Okay, so that's one way to look at it. But where is the $5 million going to be spent? Is it not in the county? It's in the county. So the $5 million is going to be spent. Half that money is being spent on them. So they are still members of the county. So if anyone leaves, for instance, some community far away from the mining area and come closer, they still benefit from that. So the total money is $5 million. It's for
time. Mr. Minister, let me correct you. Do you know about the 20%? No, I can't. This is misinformation. Let me correct it. Mr. Chairman, give me a chance. There's a lot that has been said here. Mr. Minister, are you aware of the 20% that ArcelorMittal hired my Africa to spend on our behalf? Do you know that money sat in the bank for 2 or 3 years, accruing to almost $4 million on spent money? They were accruing interest on it in a time deposit, and that interest they didn't come to the county. Up to today, contractors are staying in the field, and that money is yet unspent. If you took that $2.5 million and put it on yourself again, and put it on AML and government wide committee, this is our fear. This is our fear. Yeah, I'm not blaming Vita for it. But I'm blaming those who embody Vita to do it.
Additional information. Can we answer this question?
Mr. Minister, excuse me. Please, let me understand one another. The senators concerned, at the time the amount was
3 million.
3 million. The affected county had exclusive authority to expend at the will by project decided by them. But this time is split, and 50% of it can only be expended on the approval of AML. So that means we are saying yes. That's why you want to speak though. You want to speak though.
But that is not the situation. That is not what is written here. That is not what we negotiated. Let us take this step by step. One member and Pastor State gets it. Up to 2030, they get 3 million. After that, by this amendment, it goes up to 5 million. It goes up to 5 million. Now, when they say fenced land communities are defined clearly in Article 7A. They said the fenced land communities are towns and villages within within 1,000 meters, and they listed the county within 1,000 meter radius of the operating areas of meter.
The minister will read those things. We are aware of it.
We read these things. Why did you bring the questions up? It's going to go back and start reading to us. It's not okay. So the argument I was properly just gave your reporter today, and we'll make progress on the next point. My thing is reduced. My thing is meter has a significant portion in the implementation. On the other hand, we shouldn't be so based upon my experience with the 20%. Honorable Senator, we are all speaking to the Liberian people. We should also be given a chance to answer your question. The 5 million goes to the 3 counties. The fenced land communities are in the same 3 counties, not outside of the county. Right? So the distribution, it addresses the issue of the 20% enrichment that was made between Vita, AML, and internal affairs in 2020, which some of us actually disagree with. In fact, in one of the hearings here, specifically stated that was a breach of the existing agreement. Because you have come back to the legislature to do that amendment. So the purpose for which that enrichment was made was that the way the allocation and spending was happening in these countries, there were always issues. People were grabbing railways. People were striking. Community members, including traditionalists, were moving into concession areas and bringing production to the state. So these are provisions intended to ensure that those communities themselves become part of the decision and spending process.
Okay.
So
thank you.
the decision, the first half of the committees I refer to here will still be under the administrative and political structure that govern the country, which include county administration and county caucuses. Except that this time, decisions on how to spend the money, what project to use them for, will be made in conjunction with the affected communities themselves.
Reminder of my repeating question for you. I'm giving it back to you. I just want to remind you. The question that has to do with the transfer document between the two AMLs and then the review clause. Those are the remaining two questions of mine that I need people to throw light on. The transfer document and liabilities between the two AMLs, and why is it that there is no review clause? Because this is not also a consolidated report. So I will not be clear to say the old review stands.
Okay, so after the answer that question, Senator, they don't have to go.
Senator, I just wanted to make one clarification. The next question will be answered. Then the next question will be answered. You know, on the issue of the $5 million. Before then, there's $3 million used to go to consolidated account. Even for the country to access their money, there was a problem. But this time around, the money is going straight into the country's account. And the 50%, for instance, if like the $3 million that were on the floor before, half of it goes to Liberia County as a producing county. That $3 million, 1.5 million used to go to Liberia County. It is out of that 1.5 now. Instead of 1.5, it's now $2.5 million out of the $5 million, 50%. Out of that 50%, it becomes now the $2.5 million becomes 100% for Liberia County. Out of that 100% which is 2.5, 50% of it goes into the community account directly. Then the half goes into the country account. It's not going to go into consolidated account anymore. That's it. So it's not a reduction.
That's a deviation of that. Remember, you have answered my last two questions.
All right. In terms of, I know you disagree in terms of the provision for review, but obviously we hold the view that what applies is that there is always a 5 years review clause. A 5 years review clause by the MDA, but also provided for in the mineral and mining laws. So there's 5 years review clause for any MDA. And all MDAs have a review clause, so we never alter and we did not alter that. In terms of change of control, what we're talking about is a change of control. A change of control needs government approval. Okay? So if parent companies have documents in terms of sale, obviously it will require government approval for change of control. So if we look at this amendment, there are specific entities that we are signing the agreement with. So as it relates to this agreement, the company that we are signing, the two entities between ArcelorMittal Holdings LC and what is it next? ArcelorMittal Switzerland AG. So these are the entities that we're signing with. So with reference to your question, I do not know what we stand to lose with reference to these companies, because we're going to hold these individuals that we are signing this specific amendment with and this specific contract with.
Yes, sir. Inquiry.
Mr. Chairman, to the witness, my concern has to do with the issue of the previous MDA with Vital had left 3 years. There have been numerous complaints and non-compliance posted by ArcelorMittal. Now you are ratifying, you brought an agreement that the previous one has not elapsed, and you bring in a new MDA. to be signed. With those uncompliant activities that have to do with employment and other activity within the previous MGA, if the MGA that left 3 years elapsed and those responsibilities that are enshrined in the MGA are not met, how do you compromise it entering the new MGA which require new 25 years? So for example, what I'm saying in nutshell is, there is nothing there reflecting that whatsoever that was done in the remaining 3 years will be rolling over to the new agreement. That's a concern.
Well, the chairman and members of this committee, this particular amendment is associated with the expansion.
No,
that is not one is expansion, because we're talking about up to another 25 years. It's not this year plus another 25 years. It's not the remaining year plus another 25 years. This is an extension. And an MDA should not exceed 25 years. So in 3 years remaining, and you still want to extend, it is exceeding 25 years of going to stop. So we're not going to wait for the other year, so all the remaining year added to this one. That's why we talk about extension. You are just extending the remaining year up to 25 years. And then another thing, I'm coming, Senator. Another thing that is there is we're trying to make a better deal. What has happened in the past is what we're trying to improve now. This is the reason why we're doing all of these amendments, because we want to improve. So, and then again, putting some mechanism in place that those things that happened in the past, no violation, we don't want to wait until there is a violation, because the monitoring of this agreement, it also rests on ourselves, because in most instances there is some lukewarm attitude with respect to monitoring this thing. We want them to violate the concession, before we go there. This time we say without waiting. And this agreement is telling the company itself that you are still got to monitor yourself, because if you don't comply and there is a violation, you will pay a fine and you will also be monitoring yourself while we monitoring you as well.
The Deputy Minister answered my last question, but in the wrong way, not satisfactory. Chairman, the Deputy Minister answered the question and gave a wrong answer. I'm asking about the transfer between the two companies. He said they're dealing with the two companies and the agreement does not say so.
So, Senator Ryan, your question was answered.
It was not answered properly.
You expect the people to answer your way.
No.
They answer, you come back.
No, but this is it right here.
So what you
it said that ArcelorMittal Switzerland AG transfer all rights, entitlement, obligations, shareholdings, and the concession to ArcelorMittal USA. It didn't say the both of them operating together. And my question is, who were we negotiating with and where are the transfer documents? Because I need to know who to hold responsible in the future for the liabilities and the violations in my county.
So please answer to that.
Yeah.
Honorable Senator, the parties that we're going to the agreement with is on the top page.
So you have the answer, Senator Dillon, you have the floor. Thank you. Thank you, Mr. Chairman. In 2022, the government of Liberia, through the executive, submitted to the legislature the 10 extension of the capital reserve agreement and the 54th legislature, of which I was a part as a senator. We did not agree
with the TAIR agreement, not in rejection of ArcelorMittal as an investment company. But we did not agree, and we sent a request for extension back to the executive with concerns related to non-compliance. And that we are in 2026, and ArcelorMittal TAIR agreement or extension is back before us. I would like to ask some very pointed questions. Premise on compliance, especially for which we rejected or declined to extend ArcelorMittal in 2022. ArcelorMittal should construct medical facilities, provide education facilities and housing for their employees in the concession area and for people living in those areas. Is there any proof to show that ArcelorMittal has constructed medical facilities, provided educational facilities and housing for their employees in the concession areas? Question.
Thank you very much, Senator. Definitely, I mean, the MFDP may not be the most competent agency, but as a member of the IMCC, we are unfortunate that the entity that will best answer that question, which is the National Bureau of Concessions, which does a monitoring of those things. So we take advisement and we refer to them to ensure that they can provide those information.
Mr. Chairman, no, we don't want to take a note. The IMCC is comprised of these entities of government, including the NBC, correct? We'll take that the IMCC has met severally, meaning in their several meetings, the NBC was in attendance. Or the concerns that are just raised considered in terms of the IMCC meeting with the presence of NBC. Most times when we have people here, when we're asking for the entity and relevant institutions of government to be present, it is because we don't want one entity to say, oh, the responsibility is on the other entity in the United. So now we will be sure what we just trying to do our work. Let me repeat, sir. In 2022, I led, and I don't let the we led the suspension or the rejection of the TAIR agreement because of non-compliance by ArcelorMittal. They take care of our home, but they're not doing. In fact, right now, I don't know beside that in the future plant. ArcelorMittal built in Lima that is under construction but not completed. I think the only thing ArcelorMittal actually owned in this country since their operation was the train they have, because the pockets they inherited here from Banco. So, has ArcelorMittal constructed a hospital in Lima, in Gamma County? Have they provided housing? I'm not talking about continual route services. Have they provided housing for the employees? Education facilities for the employees, the children of the employees, and community dwellers in the concession area. Question. I will take it as we don't have answers to those questions right now, so we'll proceed. All I want to answer and tell where the hospital is constructed. Where the schools are constructed.
Senator Dino?
Yes, sir.
Thank you very much for the question. And I think all of us share similar frustration when it comes to compliance, not only of the AML, but all other concessions in the country. And we at the IMCC, as we share those frustrations also, but we are also aware that taxes needs to be raised, needs to be collected. But the point I want to make is, it requires a collective front. And I think one of the appearances of ArcelorMittal, I was here and you questioned it. So the effort